Hello, audible Hamid?
Yes, sir. Hi, I am Shishir and I welcome all the participants in this webinar. Now, without wasting time, I shall hand over the session to Dr. Bhanu Pratap, Assistant Professor, Faculty of Law, University of Lucknow. Over to you, sir.
Good evening, everyone. I'm Dr. Bhanu Pratap, Assistant Professor, Faculty of Law, and today the topic of my lecture will be Legal Monism, a World Map for World Peace. Now, first of all, I would like to apologize for the delay in the lecture because there were certain unavoidable technical glitches on our part. They have been resolved, and hopefully, it will be a fruitful lecture for all of us. Now, legal monism, as I would like to propose, it's a roadmap to peace. And previously, all of you must have enjoyed and relished through the fountain of knowledge that had been showered upon you for past 3 days. Most of you must have heard lectures by Professor Rakesh Chandra, who spoke in the most eloquent manner possible about the Kantian world peace. And just today itself, all of you must have heard Professor uh, Vijay Kishore Tiwari, who gave his views on human security and the concept of a responsibility to protect. Now, going in the same stride, I would like to discuss uh, one of the most neglected aspects of legal theory and one of the forgotten sons of international law, Hans Kelsen, and his views on world peace and his conceptual idea of legal monism. Now, legal monism, as I would elaborate in my lecture, it is a conceptual idea, a rather novel concept that was proposed by Professor Hans Kelsen, and it was his legal theoretical model for a better, tolerant, united, and peaceful world. So, if peace is to be established through law, then how will that peace be established? So, Hans Kelsen gave up his own model or came up with a project, an epistemological project called legal monism. Now, legal monism, as far as legal theory and international law is concerned, is virtually considered dead. It is no longer in vogue, it is no longer in fashion. But through this lecture, it will be our endeavor to reignite this forgotten masterpiece of international law or a forgotten piece or for a forgotten theoretical model called legal monism. And through this lecture, I would like to substantiate my argument by focusing on the idea of as to what legal monism is, how can it be related to the Kantian world peace model, and how it can be connected to the contemporary issue of responsibility to protect and other doctrines. Now, what exactly legal monism is and what are its genesis? Now, as far as Western legal jurisprudence is concerned, the idea of legal monism was propounded in Kelsen's groundbreaking work, Pure Theory of Law, which most of the students of law must be aware of. And the pure theory of law is usually understood by all of us in terms of a concept called Grundnorm, or we know pure theory of law as a normative understanding of law or a normative structure of law, that law itself is a pyramid of norms, and the validity of a law can be derived from norms, and as we progress from the individual to general norms, the highest norm being the grand norm, and that's how law comes into being through a normative structure, through a self-sustaining structure that that creates its own validity. Now, pure theory of law was a new approach. It was a new approach because, unlike all the other positivists and unlike all the other thinkers on the concept as to what law is, Hans Kelsen went on to propound an epistemic understanding of law. Now, what is this epistemic understanding of law is very important for us because it is through this epistemic understanding that we finally move on to the concept of legal monism. Now, I will recite some of the excerpts from the book itself, from the Pure Theory of Law. Now, the portion that I'm reading out right now is from the very first page of Pure Theory of Law, written by Hans Kelsen. Now, Hans Kelsen says, and I quote, as a theory, the exclusive purpose of pure theory is to know and to describe its object. The theory attempts to answer the question what and how the law is, not how it ought to be. Now, in these lines, Hans Kelsen is drawing a line as to what this book is all about. He is limiting the scope of his book. Now, by saying that he is trying to attempt as to know what law is and not what it ought to be, he is favoring the legal positivist tradition, just like John Austin and H.L.A. Hart, something that all of us are aware of. But when he says that as a theory, its exclusive purpose is to know and to describe its object. So let us focus on two words, to know and to describe. When we are focusing on the word know, we are talking about the ontology of law, what law is. And when he is saying describe its object, he is focusing on the idea as to how a particular legal system or how a phenomena can be called law. So this becomes epistemology of law. How a particular system is valid, and if it is valid, how when can we call it law? So in just one line, there are three things that have been attempted by Hans Kelsen. That is, he's talking about ontology of law and epistemology of law. So this was his special contribution to law, an epistemic understanding of law, something that was absent in John Austin and something that was not even present in H.L.A. Hart's work, The Concept of Law. Okay, so next thing that we must understand that there are certain ways to interpret the pure theory of law. Usually, and in the Indian academic system, the only thing that we are taught that pure theory of law talks about grand norm. That is the mainstay of this book. But pure theory of law is more than that. It has so many flavors, it has so many approaches that it will take a lifetime to decipher the context of this book. Such is the sagacity and seriousness of this monumental book. Now, as far as pure theory of law is concerned, there are various other ways to interpret this book and to understand the concept of legal monism. Now, I have sorted out certain areas or certain approaches to understand pure theory of law. Pure theory of law is a testament to Immanuel Kant's approach. We'll come to that later. And it is called Pure Theory of Law because the title of the book, Pure Theory of Law, has been borrowed from Immanuel Kant's groundbreaking book, Critique, the Critique of Pure Reason. So the question arises, why is it called Pure Theory of Law and not anything else? He could have called it Theory of Pure Law, but he is calling it Pure Theory of Law. He is calling it pure theory of law because he is following a Kantian tradition, and the Kantian tradition was well reflected in Kant's book Critique of Pure Reason. So what does the term pure mean? So pure, as in Kantian terminology, it was a midway approach. If you read Immanuel Kant, he adopted a middle path, just like Gautam Buddha. So, if you read Critique of Pure Reason, the main aim of that book was to find out as to how knowledge as such is possible. How is knowledge possible? So, there were two approaches as far as Western philosophy was concerned. One was the rationalist approach, and the other was the empiricist approach. Now, the rationalist approach was of the view that knowledge in this world is possible through certain a priori phenomena. That, for example, a mathematical formula. A triangle can have only three vertices. The sum of all the angles of a triangle will always be 180. So the a priori knowledge was a knowledge that was acquired independent of any sensorial experience. And empiricism, on the other hand, says that knowledge was possible only because of sensorial experiences. That means knowledge without taking into account the a priori knowledge. So Kant was of the view that knowledge is attained not fully through rationalist ideas and not fully through empiricist methods. So he created a midway approach where he combined the rationalist and empiricist approach, and he gave that approach in Critique of Pure Reason. That at times there are certain things that can be understood through our sensorial organs, and there are certain things which are a priori in nature, and there are certain things which are even beyond human understanding. He called them noumenal world, which we are not going to discuss here because it's not a lecture about philosophy. The same midway approach was adopted by Hans Kelsen. Now, Kelsen was of the view that just the way Kant approach created a middle path between the rationalist and the empiricist. Hans Kelsen, now this is a part where I talk the audience into the building. Kelsen was of the view that in his pure theory of law, or in any of the Kelsen work, he was trying to create a midway between the legal positivist and natural law. This is a very less known fact about Hans Kelsen. Now, when Immanuel Kant talked about the critique of pure reason, he talked about the idea as to how knowledge is possible without resorting to certain sensorial knowledge. Similarly, Kelsen said that how understanding of law is possible without resorting to any historical, psychological, or social inquiries. So, this is how the pure theory of law got its name. या अगर हिंदी में बोला जाए तो इस तरीके की वजह से, इस मेथड की वजह से प्योर थ्योरी ऑफ लॉ का नामकरण हुआ. Now, in addition of being a Kantian approach, pure theory of law is also represents an anti-ideological approach of law. Now, this is a very less known fact that Kant himself was a political figure, and he was opposing the dictatorial tendencies in Europe in the 1920s and 1930s. And he had an academic rival called Carl Schmitt. And Carl Schmitt was of the view that whatever is done by the sovereign becomes the law. If the sovereign is of the view that a particular point of time democracy should be suspended in the favor of autocracy or dictatorship, then that thing is right. Now, this was his political approach to law. Carl Schmitt, his political rival, he said that sovereign is the one who decides on the exception. That means politics is greater than law. Politics is creating law. Politics is creating the very infrastructure of law. And politics decide what law will be. Kelsen opposed this idea. He said, no, it's not politics over law. In fact, law is a self-sustaining phenomena which creates, judges its own validity through a normative structure. And sovereign is not something that is outside the legal structure. Everything exists within this pyramidical structure called hierarchy of norms, and at the apex stands a grand norm, a transcendental, unseen, inexplicable idea called grand norm. And this is the grand norm which validates the entire normative structure of law. And grand norm itself does not need any validation. So this system of the concept of law as such, it cannot be superseded by any dictatorial power. It cannot be superseded by any sovereign. In fact, sovereign itself comes within the ambit of law. So it is an pure theory of law. It's also an anti-ideological approach. Now, since he is not ready to accept that supremacy of politics over law. So Kelsen came up with the concept of depersonalization of state. State and sovereign is something that should not be worshipped. It is law that is final. It is law that decides the legal validity and existence of state and sovereign, not the other way around. And other way of interpreting pure theory of law is that it is called a normative approach of law, which I have already discussed. And last but not the least, pure theory of law is actually an ode to legal monism. It is a map for world peace, and it is a testament, a holy grail of the idea of legal monism. And this becomes apparent in the last two chapters of Pure Theory of Law. If you read Pure Theory of Law, the particularly the last chapter is completely dedicated to the concept of legal monism. Now, what exactly legal monism is? Now, legal monism as such talks about a concept where there shall be no artificial distinction. Now, let me remind you, let me reiterate again. There should be no artificial distinction between municipal law and international law. Usually, when we talk or even when we study, we are dealing with two different phenomena. We talk about constitutional law, we talk about municipal law, we talk about law of property. So, we talk about municipal law, right? A law that is applicable or enforceable in a particular territory, in a particular nation state. And then there is international law. So usually we say that there are two different streams of law, municipal law and international law, and they are two distinct phenomena. Now, Kelsen was of the view that if we were to interpret municipal law and international law as two different phenomena, then the vision of world peace will never be attained. Then he went on to say that if world peace is to be established, then we must abolish this dual understanding of law, its artificial distinction into domestic law and international law. And if world peace is to be realized, then we need a new approach called legal monism. Legal monism simply means that as such there is no division of municipal law and international law. There is only one phenomena, and that is law. And if there is unity in the idea between international law and municipal law, then we will be able to create a better world which is more tolerant, which is more pluralistic, and which is more understanding. Why? Because if you read pure theory of law, then by propagating the idea of legal monism, Kelsen was trying to pass a message that it is international law that works on the idea of pacifism. International law is completely dedicated to the concept of world peace. Because let us not forget, one of the foremost duty or one of the foremost reason for creation of international law was for the subjugation of the just ad bellum regime. So international law is working for world peace. All of you must have heard this idea in various lectures. Vijay Kishore sir must have dwelled on this idea, and the concept of peacemaking was discussed by Ms. Swati Singh Parmar, and Rakesh Chandra sir spoke about the world peace model. So the concept of peace as such is a burden that has been given exclusively to international law. Municipal law, on the other hand, may or may not work on the idea of peace. Because let us not forget that municipal law is working on the meta ethics of nationalism. Nationalism usually can be dangerous. And if we see the current scenario, There is rise of right-wingist governments all over the world. So nationalism may degenerate into jingoism. It may develop a tendency of solipsism. It may develop a tendency of chauvinism, saying that Mera Rashtra Mahan is not a bad thing. But if you go on to say Sirf Mera Hi Rashtra Mahan, then that may create problem because that may lead to jingoism and hyper nationalism, something that we are seeing all over the world, even in times of a corona crisis. Now, as far as legal monism is concerned, it is opposed by two other uh, stream of thoughts: legal dualism and legal pluralism. Now, legal dualism is it's very simple. If legal monism is talking about a single integrated legal system where there is no artificial distinction between national and international law, then legal dualism, as propounded by legal positivists like Tripel and Ancelotti and Hegel, they are of the view that there is necessary distinction between two streams of thought. There is the national law and there is international law. Both have different spheres of working, both have different scope, and both have different system of validity. And ultimately, it is the national law that triumphs over international law because international law itself is created by the consent of the states. So we can see that the idea of legal monism is opposed by legal dualism. Then you have the idea of legal pluralism. Now, when we talk about legal pluralism, it is a combination of legal monism and legal dualism. If legal dualism says that there are two circles of law, namely national and international law, and they may intersect with each other. But legal pluralism is of the view that just like legal dualism, it agrees on the point that national and international law are two different things. And instead of intersecting, national and international law may overlap. But they are not ready to accept the idea that national law and international law form a part of single integrated system. So the idea of legal monism is opposed by legal dualism and legal pluralism. Now, the next obvious question that arises, and that will be taken up by me, is that why do we need legal monism in the first place? Zarurat hi kya hai? Now, since we have been talking about the concept of peace, and we have discussed certain hypothetical models or philosophical models, something that Immanuel Kant had worked, and all of you must have heard from Professor Rakesh Chandra about the concept of perpetual peace or federal peace model, then legal monism is needed because in the 21st century we can witness certain disturbing phenomena, and that is why we need legal monism more than anything else. First, we can say the concept of hyper nationalism and jingoism, which I had already mentioned. Nationalism as such can be very dangerous because nationalism, if you trace its history, it's a particular European phenomena, and it imbibes or necessitates a system of competition. Okay, nationalism and competition go hand in hand. One nation is trying to compete with other nations, whether on the narration of glory or for acquiring more power, for fighting for more resources around the world. So competition is the base of nationalism, and as such, the concept of nationalism desires a geographical consolidation of power within a particular territory where people have a common narrative, and these people are protecting this common narrative, which can be a single unified a culture, a single unified religion or language. It can be anything. So people are jealously trying to protect that identity. So when you're trying to protect your identity through a narrative that is primarily political in nature, then obviously you're going to pick a fight, or you may have competition with your neighbor, something that is counter to the idea of world peace. Now, if you look at the some of the disturbing phenomena that have cropped up or are detrimental to the concept of peace, then is something that we can see is the rise of right wingist governments all over the world. Okay, so you're seeing this phenomena in South America, you're seeing it in Britain, in USA, in Brazil. So right wingist governments are taking over the governmental functions, and these governmental functions are using nationalism as a propaganda. So the narrative, if we talk about a single unified world, or Vasudhaiv Kutum, or if you want to talk about international peace, then the right wingers are having a narrative of their own, where they are creating a narration or a story of us versus them. The latest the latest narration being corona being labeled as Chinese virus, and this is being endorsed by the president of United States of America. So we can see that hyper nationalism and jingoism are not favoring in the world of legal monism, or world peace. Now, there are certain geographical and political factors which have affected the world peace and the idea of legal monism. Such can be the refugee crisis and the rise of xenophobic tendencies ever since the 2008 subprime mortgage crisis. Now, if we look at the political structure and historical structure of the world in the past 10 years, then with the advent of subprime mortgage crisis, protectionist policies gained momentum all over the world. And with the happening of Arab Revolution, where so many Middle East countries demanded democracy, and the authoritarian government tried to clamp down the dissenting opinions and started persecuting its own citizens. Then there was a huge migration of the Middle East people into the various European countries, and with this migration came they imported their own culture for taharrush, which was not acceptable by the Europeans. And slowly there was a xenophobic tendency towards the Middle East people, towards Chinese, and all the people who had lost their job or who were alienated from their culture. So this was also a very big issue, and these are the exact tendencies that legal monism is trying to combat by establishing the supremacy of international law over municipal law. Now, the next method through which legal monism tries to assert itself, it tries to reconceptualize the very basis of international law. So, if we are looking at the basic concept of law, a very idea of law that we said, then we must talk about the concept of sovereignty. Because if there is no sovereignty, then state cannot have a legal personality. So sovereignty is one of the cornerstones of international law. And sovereignty, as most of us are aware of, and if you have studied international law, then sovereignty is considered as the right of the state, unbridled right of the state. Sovereignty, as far as international law is concerned, is considered to be Westphalian sovereignty, the absolute right of the state to create law for its own consolidated territory and to prohibit the use of force against its territorial integrity and to protect itself from external aggression and to have a juristic legal personality. Now, in the garb of Westphalian sovereignty, the state considered themselves as supreme, as the makers of international law. And this Westphalian order went on to create a political system where the states considered that waging war was also a part and parcel of sovereignty. And this obviously was not the case. So, the concept of Westphalian sovereignty was primarily political. the political scenario was overpowering the legal structure. Legal monism goes on to create a U turn. Legal monism subjugates the concept of sovereignty under the legal system. Legal monism says that sovereignty is not something that is existing outside the legal system. It is very much a part of the normative structure of law. International politics or sovereign is subjected to law. It is not above law. It is very much it is very much a part of the normative structure of law. It gains its legal existence only through law. So sovereignty as such cannot exist independently in a political scenario. So what legal monism does, it talks about the juridical pacification of international relations. It talks about depersonalization of sovereignty. It takes away the political mask of international sovereignty and gives it a legal understanding or a legal existence. So sovereignty as such is subjugated to law as such. Now, if we look at the concept of sovereignty and nation and how it is experience and how it was experienced in the Indian legal culture, then there are certain historical uh, contingency that we must understand. Sudipta Kaviraj is of the view that sovereignty and the concept of nationalism, they were contingent in nature, they were politically and historically contingent in nature as far as the Indian subcontinent experience was concerned. Sovereignty, as understood, is a monolith system, a single consolidated phenomena where a sovereign is making law and it is being applicable to the citizen, the top to bottom approach. Before the East India Company came into being, such a sovereign system was not practiced by Indian rulers. Administration, as carried out in India, was decentralized and pluralistic in nature. India was not working within the Western sovereign system. It had its own system. India was being governed by two sovereigns, the government and the society. The societal relations were having as much effect as that of government's order. But this system was replaced by East India Company because when they started administering India from a distance, then they introduced their understanding of sovereignty. They introduced their own Hobbesian and Austinian understanding of sovereignty, and that is how India came to be governed by the Western sovereign system. Otherwise, the previous system was not based on this idea. And the same thing can be said about nationalism. Nationalism and sovereignty have been imported into our culture through the Western legal tradition. So the Austinian way and the Hobbesian way was not the Indian way. It was incorporated by the work of East India Company. Now, legal monism, in order to be effective, must work on the concept or must work on the idea that international law itself is a law, is a binding law. As most of us have attempted a question in the first semester of the graduation, whether international law is a law or not, which itself is a, an illogical question. अभी तो ये पूछने की कोई जरूरत नहीं है. But international law, of course, it's a law nonetheless. Cedric Reinhardt, in his recent book, International Law from a European Perspective, has given a monumental statement regarding the status of international law. He is of the view that international law has entered a post ontological stage. Post ontological state where the question itself, international law is a law or not, is a moot question. Is no longer required because it is a law. Hans Kelsen goes on to say that if you accept municipal law as a law, you do it because you say that law has sanctions. And the same sanction mechanism is present in international law in the form of retortion, reprisal, countermeasures, and collective security. So both international law and municipal law can agree on the idea that both have sanction system. And if you resort to the idea of Louis Henkin, who in his book How Nations Behave was of the view that sanction is not the quintessential element of international law. International law is a law because by accepting international law, the state actors want to project themselves as responsible actors who should be taken seriously in international politics. Now, if you look at the idea of international law and legal unity, then this is where legal monism comes into being. International law, in order to promote and protect peace, must create a system of legal unity. There has to be legal unity between municipal law and international law. Otherwise, municipal law is very chauvinistic and arrogant in nature. As most of you must have read in constitutional law, that whatever is said by constitutional law is supreme, and if the legal culture of a country does not accept international law, then it will not be binding. It is completely up to the executive and judiciary whether to accept international law or not, even if international law is providing the right way. So, such chauvinistic and selfish interpretation of law can only be avoided only when we understand municipal law and international law as a single integrated phenomena. Okay, so if we are of the view that international law and municipal law are at loggerheads, and if we are of the view that law should be understood as a single integrated phenomena, or if we are considering the triumph of international law over municipal law, then how is it possible? Because it is only a theoretical uh, uh, it's a theoretical model, but as such it has to be practical too at times. So in his work on problems of sovereignty and international law and in pure theory of law, Hans Kelsen talks about the two versions of primacy. When I talk primacy, it means whether international law prevails over municipal law or municipal law prevails over international law, right? So there are two methods. Either national law prevails over international law, or second, international law prevails over national law. So these are the two options that are available to us. Okay. Now, if international law is allowed to be prevail over international law, then again we are going to move in circles. We'll back to square one. So if there is a situation, let's say torture, international law says that torture as such is prohibited completely. But the national, as far as national law is concerned, and it goes on to create an act passed by its parliament where torture can be applied on terrorists, then we can see that there is a dichotomy or disagreement between international law over the application of torture. So, national law as such can be solipsistic, it can be narcissist, and it can violate the human rights of any person. But international law, on the other hand, would never do that. So, as far as national law and international laws are concerned, which one is to prevail over who? This idea was considered by Hans Kelsen, and he called it the choice hypothesis. Now, choice hypothesis means that Kelsen said that it is up to the legal jurist which mode he wants to create, whether it is national law over international law or international law over municipal law. Now, even the academic life of Hans Kelsen can be divided into two parts, and during this two period, we can see a young Hans Kelsen and an older and wiser Hans Kelsen. So, if you visit his work during his younger days, then Hans Kelsen always talked about the primacy or the triumph of international law over national law. If you read the original version of Pure Theory of Law that was published way back in 1930s, in that book he talked about the triumph of international law over municipal law. But as he aged, so when he became pretty mature in 1960s, he came up with choice hypothesis that it is up to the jurist to select whether national law will triumph. But his choice hypothesis, his idea of choice hypothesis were contested by his own two students, by his two students, named most famously by Alfred Verdos. Now, Alfred Verdos, who in today's world is called the father of international constitutionalism, he was of the view that choice hypothesis as such is not a very good idea. It should always be the international law that should triumph over municipal law. Now, if we talk about the triumph of legal monism, then how is it possible? Because we are talking about the idea of Hans Kelsen and we are talking about pure theory of law. Then, if international law is to triumph over municipal law, it should have precedence over international law, then how can we do that? So, as far as legal monism is concerned, what lies at the apex is a grand norm, and that grand norm is delegating some of its ideas to international law, and international law is delegating and creating different national legal systems beneath it. So at the apex you have the grand norm, which is the highest norm, which is without any content, an idea which is transcendental in nature, which is beyond the cognition of any legal theorist. Or in a nutshell, we can compare grand norm to the concept of time, space, or God. It is because of the existence of this grand norm that other norms are possible. And all the norms are tracing their validity from a higher norm till you reach the grand norm. But grand norm's validity cannot be tested. It is a priori in nature. In the absence of grand norm, no legal structure can exist. So at the apex, you have the grand norm. And then you have international law, which is validating the different national legal systems. So whatever international law says will be supreme. Now, Hans Kelsen contemplated on this issue that should grand norm, or if you're going to place international law above the municipal law, then should it have a content? So if you're talking about the triumph of international law, should grand norm have a content? Various theories were propounded. Hans Kelsen gave up a certain very good idea. Now, as far as the content of grand norm is concerned, initially Kelsen said that what should be the grand norm of international legal order? He called it custom. Customary international law should be the grand norm of international law. Some theorists were of the view that treaty should be the grand norm. Pacta sunt servanda, that should be the grand norm. But these two theories were rejected because one of the main constituents of a grand norm that it has no content of its own. So if you are going to make custom and treaty as a grand norm, then it is well known that custom has two contents: opinio juris and state practice. Similarly, treaties have the content of their own. So grand norm, if it is supposed to be contentless, how can it have how can it say that content and treaty are the grand norm when they themselves have content? That is going to invalidate the concept of uh, the grand norm itself. So what exactly is grand norm? I'm sorry, I missed out one more point. An argument has been made that Article 38 of statute of ICJ, right, which talks about sources of international law, that should be a grand norm of international law. But even that cannot be done because the content of sources of international law may change. Marxists are of the view that ideology should be considered another source of international law. Recently, theorists are of the view that judicial interpretation should also be included in the sources of international law. So, the list that has been given under Article 38 is not exhaustive, it will keep on increasing. So, the content is there, and grand norm should not have a content of its own. Now, how will international law create or delegate, because if you're talking about the hierarchical structure of a normative theory of international law, then one norm is going to validate another law through the principle of effectiveness. Effectiveness means the practical application of law, whether a law is really practically applicable, it is being observed. So if at the apex you have the grand norm, then you have international law, and within the international law you have the different national legal systems. So how is international law assuming superiority over national law? Number one, it is a higher norm. And why is it a higher norm? Because through principle of effectiveness, it is permeating or allowing national legal systems to exist. Now, there's one simple logical answer about the superiority of international law. Why are we calling it is superior to municipal law? Because municipal law will exist when there are sovereign states, right? If you look at the preamble of Constitution of India, it says that we the people of India having solemnly resolved to constitute India into a sovereign socialist secular democratic republic. The first thing that comes is sovereign. If you're not sovereign, you're not a state. If you're not a state, you cannot even have your own constitution. And who decides whether a particular state is a state? Who decides whether a particular state has sovereignty or not? It is not decided by the constitution. It is the sole domain of international law. So nation state is coming into being because it has been called a state, it has a legal personality. And who vests that international legal personality upon that state? It is international law. So, logically speaking, international law is responsible for the creation of not only state but of all the national legal system all around the world. So, even logically speaking, and in a normative structure, international law has a superiority as a legal superiority over international over the municipal legal system. And if you look at Article 27 and Article 46 of Vienna Convention of Law of Treaties, then it clearly says that if as far as the municipal law of a member state is concerned, no member state can use its municipal laws to shy away from its international obligations. If you have signed or ratified a particular treaty, then you cannot go on to say that your municipal system is not supporting the idea, or the opposition support नहीं कर रहा है, या अभी हमारे पास infrastructure नहीं है, parliament में majority मिल पा रही है. None of that excuse is going to work as far as international law is concerned. So by virtue of pacta sunt servanda, you are bound by the treaty. It doesn't matter how you're going to run your municipal system. You have to comply with your treaty obligations. Now, if we were to talk about the application of pure theory of law, or if you're trying to incorporate, or if you're working on a hypothesis that pure theory of that legal monism is one of the pertinent aspect of pure theory of law, then we'll have to tweak the understanding of pure theory of law as such, because pure theory of law is talking about the cognition of the phenomena of law without resorting to psychological, social, political measures. It is against the concept of natural law. It is not going into the morality of law. But when we talk about the triumph of international law, we are talking about world peace. And world peace and human rights, these are value laden subjects, very well discussed in the natural law tradition. So we can say that Hans Kelsen was trying to incorporate or was trying to import the natural law tendencies through backdoor, because his idea of legal monism is just mentioned in pure theory of law. Hans Kelsen makes a radical departure from his positivist tendencies in another book called Peace Through Law. And it is in Peace Through Law where Hans Kelsen starts to build a world peace project of his own. And it is in Peace Through Law that he deviates from legal positivism and starts incorporating certain values in the international legal system. So, if you were to discuss pure theory of law as legal monism as one of the aspects of pure theory of law, then we'll have to do a heretic, a radical interpretation of Kelsen's pure theory of law, because, as I've already mentioned, it may allow the incorporation or importing of the value system in a legal positivist tradition. And I've already mentioned that pure theory of law, if you read in its entirety and if you trace the Kantian roots of Hans Kelsen, it is a midway approach, a middle path between legal positivism and natural law. Even if you read Immanuel Kant's critique of pure reason and practical reason and critique of judgment, in critique of pure reason, he talks about the cognition of knowledge. But at the same time, he also discusses the ideas of ethics which were incorporated in critique of practical reason. So, as such, there is no watertight compartmentalization as to this book is dealing only with this subject and the next book is dealing with this subject. We have to do a heretic and radical reading of Hans Kelsen as such. Now, if we look at legal monism, then in Kelsen's work, because Kelsen has he lived for a very long period of time. He died when he was 90, and during his 90, during the lifespan of 90 years, he wrote more than 360 books, books and article combined, 368 to be precise. Then, if Kelsen talks about legal monism, he is talking about a form of government that should be embraced by all the national legal orders, and that is democracy, because democracy comes closest to rule of law. It talks about the objective nature of law. You cannot talk about an objective nature of law or the objective binding nature of law in a dictatorship. In a dictatorship, it is always politics over law. So if you are talking about world peace, then democracy is the way to go forward, because in a democracy you'll have a constitution, and constitution is an objective reality. Constitution subjugates the politics, and constitution should be seen as a tailor of power, right? So democracy is an aspect of legal monism. And if we look at Kelsen's later work, Peace Through Law, which I had already mentioned, in Peace Through Law, uh, Hans Kelsen developed an international organization of its own. He wrote it in 1944, and this was a transition period where League of Nations had been dissolved and the Charter of United Nations had not come into being. So Hans Kelsen uh, created or put forward an idea of an international organization called Permanent League for Maintenance of Peace. So it was his proposal, it was his world peace model, where there were primarily four organs: an assembly, a council, a court, and a secretariat. And within this peace model, Immanuel Kant made the judicial organ the strongest. So, international judiciary, according to him, was supposed to be the strongest part of international law. The declaration of war, the imposition of countermeasures of sanction could not be done until and unless it had obtained the sanction of an international judiciary. That were the views of uh, Hans Kelsen. And Hans Kelsen, in this book, Peace Through Law, he was arguably one of the first thinkers who talked about the individual criminal responsibility in international criminal law. And this hypothetical idea, this imaginative world code that he was talking about, was to be comprised of international criminal lawyers and municipal criminal lawyers. So this was a very progressive vision where international judicial was stronger. Sanctions were to be imposed by international judiciary and not by the council. Now, as far as Hans Kelsen is concerned, and if you recall your lecture on uh, 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 perpetual peace model, then it is a popular notion that Kantian peace model is promoted democracy, whereas this is not the case because because Immanuel Kant was against the idea of democracy. And if you read Perpetual Peace, in a footnote, he said that democracy is the least preferred model of governance during his time. And Kantian peace of model does not use international law as a base. The base of Kant's perpetual peace model is philosophical. It is categorical imperative, whereas the base of Kantian peace of Kelsen peace model is pacta sunt servanda. So Immanuel Kant does not use uh, international law as its base. In fact, Immanuel Kant was against the idea of international law. He called Hugo Grotius a sorry comforter of law because he was very much a nationalist. He believed in the supremacy of state over international law. Now, how can legal monism be manifested? How can we realize the notion of legal monism? How can we say that there are times where international law will triumph over municipal law? Then the answer is simple. If we look at the Charter of United Nations, Charter of United Nations, which has now been accepted as an international constitution, it talks about the supremacy of international law or international constitution. So the word constitution is not only limited to municipal law, it has been imported at an international sphere. And recently, Professor Fassbender has written a separate book as to why Constitution Charter of United Nations is not only a mere treaty, it is a constitution that stands above the member states. Now, when we talk about an ordinary contractual treaty in international law, when we talk about an ordinary contractual treaty in international law, then that treaty simply means simply one of the essential characteristics of that ordinary treaty is that states are the masters and creators of that particular treaty. If it is a mere contractual treaty, they can withdraw whenever they want. Whenever they want to withdraw from a treaty, they can withdraw it. And the powers that are given to a particular international organization are those which have been specifically conferred by the member states. Now, when we talk about a treaty which is not a contractual treaty but a constituent treaty, a treaty that has been given the label of a constitutional treaty, then in that treaty, when the treaty is created, then that particular treaty, that particular international organization assumes a separate independent life of its own, and its laws are superior as compared to its member states. That particular international organization is not dependent on its member states. The member states must now follow the law of international organization. And the doctrine of implied powers is always present in a treaty which has a constitutional nature. If you look at the purposes and principles of the Charter of United Nations, they are now a part of just cogence. They are inviolable. No country, no matter what they do, they cannot break these laws. If you're going to attack one country and you say that you are sovereign enough to declare a war, and declaring of war is a part of your municipal order, then the idea is simple. That notion, that understanding is invalidated by Article 2, Paragraph 4 of the Charter of United Nations. And if there is a constitution, then a constitution, uh, there's a legislature, there's an executive, there is a judiciary. So there is a lawmaking tendency, there is problem, there are exercises of execution, and then you have an international judiciary. So we can consider General Assembly as to performing these legislative functions, though it's not a world parliament, but some of the resolutions that have been created by the General Assembly, they have attained the status of international law. And not only any international law, it has they have attained the just cogent status. For example, the Declaration of Friendly Relations of 1970. Even Security Council is involved in creating certain resolutions which have labeled Security Council as a quasi legislative organ. It went on to create a resolution called resolution number 1373, where it was obligatory on all the member states to create anti-terror laws. Now this resolution was passed in the time of 9/11, and after this, the passing of this resolution, the member states had to change their municipal laws, and they enacted anti-terror laws. For example, we have the Patriot Act in United States of America, and we had the POTA Act in India, which has been repealed. Now, if we look at the manifestation, how legal monism can be practiced in international law, we can see the doctrine of responsibility to protect. Now, today, Dr. Vijay Kishore talked about the concept of responsibility to protect at length. Then all of you must have heard that responsibility to protect has reconceptualized the idea of sovereignty and intervention. We are saying that sovereignty is no longer the right of the state, rather it is the responsibility of the state to guarantee certain basic civil liberties to its citizens. Then responsibility to protect, as such, as all of you must be knowing by now, that it has three aspects: responsibility to prevent, react, and rebuild. Now if we look at the third aspect of responsibility to protect, that is responsibility to rebuild, we can see that international law is guiding the national legal system. Let us see how. Responsibility to rebuild is a tool which talks about a situation where a country which had been uh, witnessing civil wars, or which was under a dictatorship government for a long period of time, and now if a particular dictatorship has been removed and a new democratic government is being brought into being, then how do you inculcate certain basic constitutional values in that particular failed or weak state, so that particular state does not relapse into the same situation again? Then if you look at the toolbox of responsibility to rebuild, then it talks about certain basic constitutional values. It talks about rule of law, it talks about democracy, it talks about human rights, it talks about good governance. So all these tools, which we consider as a part of domestic legal system, is actually a part of international law. And now international law, through responsibility to rebuild, is directing the basic setup of the municipal law of a particular country. So it is making state a responsible and responsive state. So its municipal system is being created and nurtured by international law. And this is uh, the aspect of responsibility to protect that is not being discussed in the academic circle. Responsibility to rebuild is actually a manifestation of legal monism in a practical scenario. This is how legal monism, through effectiveness, is affecting national legal orders. And let's not forget the pandemic crisis. Now, some of the terms that have made inroad into our ordinary parlance, like quarantine or social distancing, all these words are emanating from international law. These measures that the government is taking, they have been borrowed from Article 18 of International Health Regulation. And in order to combat a situation like pandemic, you need the guidance of international law. In fact, if it wasn't for World Health Organization, or if it wasn't for the knowledge of international law during times of pandemic, national legal system, in all probabilities, must have fondled the entire system. And last but not the least, I would like to conclude this session by citing the word of Govind Chandra Dev. Now, Govind Chandra Dev was a brilliant scholar from Bangladesh who's not very well known in the Indian subcontinent, and his work has receded into oblivion. He was one of the first exponent of monism and legal monism in the Indian subcontinent, and he wrote a seminal book which virtually went unnoticed. And the name of the book was Idealism, a New Defense and a New Application. I would like to conclude my ideas on legal monism and my views on world peace by quoting Professor Govind Chand Dev. And I quote him: "We can achieve a thoroughgoing appreciation of the real and equal humanity of all human beings, one in which national boundaries will disappear, and religious divisions likewise, thus removing the rivalries and dissensions they encourage. If Krishna, Buddha, Christ, and Muhammad could be found together, they would have assuredly vied with one another in superlative love and friendship. But, curiously enough, their so called followers do not hesitate to paint them at times as arch commanders, as it were, of belligerent forces fighting hard for what is wrongly called a spiritual conquest." Now, in his work, if humanity, if humanity were to be treated as the end of any law, then the world has to be seen as a single integrated system. The artificial distinctions between nationalism and boundaries, they must cease to exist, and the world should give way to a pluralist, cosmopolitan, and more mature world. And that was the vision of Hans Kelsen. And I hope through this epistemic endeavor of our department, many of you will be encouraged to read, to speculate, and to imagine a community that is more tolerant and that is more responsive and more conducive for a peaceful world. Thank you so much.
Now, I would like to thank Dr. Bhanu Pratap sir for his insightful content on legal monism and world peace, and his wonderful remark on legal monism as depersonalization of state responsibility. Thank you, sir. Now, I would like to hand over the session to Mr. Saksham Agarwal.
Good evening, everyone. Dear participants, honorable chief guest, professors, and other dignitaries. We are on to the valedictory session of this 3-day webinar that is on quest for international relations in 21st century. Today we have with us Shri Rahul Agarwal, who is an advocate in Allahabad High Court. Sir did his LLB from NLS Bangalore, and he's very young lawyer who is practicing in the field of taxation and service. We are grateful to have with us Sri Rahul Agarwal today. We have also with us Professor R.K. Singh, who is former Head and Dean, Faculty of Law, University of Lucknow, Professor Mohammad Ahmed, Director Placement Committee, and other organizing committee members. Now, I would like to invite Professor R.K. Singh sir for delivering the presidential address. Sir, please.
Thank you, Sacham. First of all, I would like to thank the organizer for organizing this wonderful events. And the topic for the today events is also very much contemporary quest for international relationship after the post-COVID. Though I am not very much acquainted with the international relationship of all the countries of the world in a very thoroughly manner, as the our professor Dr. Bhanu Pratap has a lot of knowledge over the international affairs, and I am very unfortunate that I could not hear all his lecture on the legal monism, because I was very much interested to listen this kind of the lectures, but okay, I have missed it. I hope that again I will get the opportunity to listen his lecture on legal monism.
Absolutely, sir.
As far that today webinar is concerned, I would like to also thank the organizer Muhammad Ahmad Sahab. Time and interval he has organizing this kind of the webinar, and our faculty is now going to day after day in a pinnacles which we have also expected from him, that so many effort he has been made to organizing this kind of the events. And but I'm watching it that all the event are being organizing on the international law and international relationship after the post COVID. So today topic as far as the quest for international relationship is concerned, no doubt about it that after the COVID-19, when the impact will be reducing day after day, now this time it is very difficult for all of us to understand that when and how it will be totally eradicated from the earth. Someone says that okay, we have to live with the COVID-19, and this disease will not be totally eradicated from the earth. So definitely, when all the country of the world are facing a very acute problems through this disease, and the whole life as well as the lifestyle of the human being are being totally changed after this COVID-19. Now this time, as far as the impact of COVID-19 in my point of view is concerned, that it is very early to assess the impact of after the COVID-19, because as far as the international relationship is concerned, it is very difficult for anyone to guess it that which relation with which countries are going on ups and down. It is very difficult for anyone to understand it that what is the relationship between the China and America now this time, what is the relationship with the China and India now this time, what is the relationship with the India with all other countries are now this time. It is very difficult for anyone to guess it. We are all struggling first to uh, get rid from the this disease. I'm going to say about the COVID-19. All the country of the world are facing to save their own citizen through its own equipment, through its own resources. And our Prime Minister Narendra Modi ji has also very much clearly stated that now time has come when we have to become Atmanirbhar. क्योंकि ये जो आत्मनिर्भर का जो नारा हमारे प्राइम मिनिस्टर साहब ने दिया है, नो डाउट अबाउट दैट इट इज वन ऑफ द ग्रेट स्लोगन, एंड आई फील इट दैट कि वी कैन सेव आवर लाइफ, वी कैन सेव आवर सिटीजन थ्रू ओनली दिस स्लोगन. हम लोगों को आत्मनिर्भर बनना ही होगा, और जो भी कंट्री आज की डेट में अपने अपने नागरिकों को, अपने व्यक्तियों को जो भी अ, अपने तरीके से, अपने रिसोर्सेज को इस्तेमाल करके, अपने डोमेस्टिक रिसोर्सेज को जितना भी बढ़ाकर लोगों की जान बचाने में कारगर साबित होगी, अपनी अर्थव्यवस्था को एस्टेब्लिश करने में जितनी कारगर साबित होगी, वही कंट्री जो है वो आज के पोस्ट कोविड के दौर में, आफ्टर द कोविड के दौर में, वही कंट्री जो है वो वर्ल्ड के मैप पर वो मजबूती से खड़ी होगी। सभी कंट्री जो है, सभी देश आज की डेट में स्ट्रगल कर रहे हैं अपने सिटीजन को बचाने के लिए, और ज्यादातर, नो डाउट अबाउट दैट, इन अदर वर्ड it is also a truth that state cannot meet their own needs for dealing with the uh, uh, crisis through their own domestic product alone. Globally, if you see that supply chain means they will depend upon import from so many things, just like medical equipments, mask, pharmaceutical machines, and so many other resources. A country has to depend upon the other nations. तो ये कहना कि किसी भी कंट्री के साथ हमारा रिलेशनशिप क्या होगा, या हमारे साथ किसी और कंट्री का रिलेशनशिप क्या होगा, ये बड़ा मुश्किल है ये आज की डेट में बताना. बट वन थिंग इज वेरी क्लियर दैट अंडर दिस सिनेरियो आई रिकॉल द principle of Duguid. There is a concept of social solidarity. Each and every country of the world are totally dependent upon the other countries. क्योंकि कोई भी कंट्री दुनिया में ऐसा नहीं है जो अपने रिसोर्सेज से अपने आप को खड़ा कर सके. तो ऐसी स्थिति में मुझे लगता है कि पोस्ट कोविड के दौर में, या जो आपका टॉपिक है क्वेस्ट फॉर इंटरनेशनल रिलेशन आफ्टर पोस्ट कोविड, वो इंटरनेशनल रिलेशनशिप तो बना ही रहेगा एज एनी हाउ. हाँ, कुछ उसके इंग्रेडिएंट चेंज हो सकते हैं. कुछ ऐसे कंट्रीज हैं जो अपने आप को अपने पॉलिसी को चेंज कर सकते हैं, लेकिन एज फार द इंटरडिपेंडेंसी ऑफ द अदर कंट्रीज इज कंसर्न, इट विल रिमेन इंटैक्ट. क्यों? क्योंकि आज की डेट में कोई भी ऐसा देश नहीं है जो टोटली आत्मनिर्भर हो. भारत भी कई मामलों में विदेशों के ऊपर डिपेंडेंट है, और इंटरनेशनल जो कंट्रीज हैं वो भी कई मामलों में भारत के ऊपर डिपेंडेंट है. तो इंटरडिपेंडेंसी तो मेरे ख्याल से बनी रहेगी, क्योंकि आज के डेट तक 2 लाख सिटीजन मर चुके हैं और 3 मिलियन केसेस जो हैं वो कोविड के अभी भी सरफेस पर हैं. कितने लोगों की जान जाएगी, कितने लोग अभी भी और भी इफेक्टेड होंगे. सुनने में आ रहा है कि 1-2 महीने में ये और भी तेजी से बढ़ रहा है, और जिस कंट्री में खत्म भी हो गया है वो फिर रिवाइव हो चुका है. तो ऐसे स्थिति में उस कंट्री का क्या कंट्रीब्यूशन होगा, और लोगों का कैसे इस पर काबू पा पाएंगे, कैसे साइंटिफिक इन्वेंशन इस तरह से किया जाए आपसी कोऑपरेशन की वजह से की तरह कि सभी कंट्री जो है अपने रिसोर्सेज से, अपने इन्वेंशन से, अपने एक्सपेरिमेंट से सभी कंट्री को सहायता पहुंचा सके, ऐसे हम लोग उम्मीद कर सकते हैं. वैक्सीन की खोज जारी है. सभी कंट्री जो है अपने अपने तरीके से, अपने रिसोर्सेज से इस बीमारी को काबू करने के लिए पूरी तरह से दृढ़ संकल्पित हैं. जब तक वैक्सीन नहीं बनेगा, इट इज जनरली सेड दैट कि वी कैन नॉट बी टोटली क्योर फ्रॉम दिस डिसीज. तो हम लोगों को वेट करना होगा. कितने दिन लगेंगे अभी कहना मुश्किल है, लेकिन एक बात तय है कि ऑल द कंट्री ऑफ द वर्ल्ड मस्ट हैव टू रियलाइज दैट कि किसी की मोनोपोली नहीं चलने वाली है आने वाले समय में. सभी को इंटरडिपेंडेंसी का जो रूल है उसे मेंटेन करना होगा. सभी कंट्रीज को अपने डिमार्केशन में, अपने जुरिडिक्शंस में, अपने 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 क्षेत्र में जो है उसे उसी तरह से सहयोग करना पड़ेगा जैसे कि वो अन्य अपने लिए चाहता है और अन्य देशों के लिए चाहता है. तो यही एकमात्र सलूशन है. और जहां तक बात हो रही है कि चाइना विल अटैक ऑन इंडिया और चाइना विल अटैक ऑन अमेरिका, आई डोंट थिंक दैट दिस काइंड ऑफ द this kind of the notion is still continue in the present scenario, क्योंकि जब हर एक देश अपने नागरिकों को बचाने में जद्दोजहद कर रहा है, ऐसे स्थिति में हम लोगों को वार के बारे में सोचना और खासकर जो इंटरनेशनल कोवेनेंट्स हैं, इंटरनेशनल जो चार्टर है, उसके उसके अंतर्गत वार के बारे में कल्पना ही करना अपने आप में बड़ा हास्यास्पद है। तो ऐसी स्थिति में वार तो खैर बहुत ही दूर की बात है, क्योंकि जहाँ तक इंटरनेशनल लॉ का सवाल है, मुझे नहीं लगता है कि इतना आसान है किसी भी कंट्रीज के ऊपर आज की डेट में अटैक करना। और बट फिर भी लास्ट में मैं ये कहना चाहूँगा कि जो इंटरनेशनल सिनेरियो बन रहा है, वैसी स्थिति में इट इज नीड ऑफ द आवर दैट ऑल द कंट्री ऑफ द वर्ल्ड शुड बी कम अंडर वन फोरम and try to fight with this COVID-19 unitedly, then I think the problem will be solved. Thank you very much for giving me an opportunity to express my view on this webinar. Thank you.
Thank thank you, sir.
Now, I would like to call Shri Rahul Agarwal, Advocate, our today's chief guest, for his address.
I'm not sure if I'm audible.
Yes, sir, audible.
The video is interrupted. I can't. I am audible, though I'm
So you can uh, close your camera and try audio only.
ending the valedictory session of the webinar.
Hello?
Topic that we have we've heard over the last couple of days. Very interesting. From my perspective, today it is not so much world peace. I don't think we've had peace in the traditional sense of being contrasted with war in the international sphere, barring the invasion in Iraq or Afghanistan, and that also for very particular reasons. We've not had territorial conflicts. For me, peace today should actually be calm, not world peace, but world calm. And in today's day and age, it is not peace versus war that we are talking about, but calm versus settled ways of disruption that has been caused by over the last seen how it is pretty much that the entire and blame the complete disruption in global politics, global trade, the way of life, the complete the COVID has effectively acted as a catalyst, feeling against China with barriers being erected by pressurize the EU also to impose tariffs on China. Once again, despite a where international order is again many ways in which and we saw in the to
I think there is a
the
audio
Chinese
problem.
mobile. Sorry, you said something I can't. I'm role in the Kashmir. Nepal is being prodded by China. They're making claims over issue today is manage relationships so as to keep introduced into the all of it Marxist theory comes down to making sure that your own are happy, are prosperous. It is, I agree, it is not all right at the moment to blame China for everything. China, in my opinion, or understand it. It was a pent up feeling which is now coming out. Have been sent to China in the manufacturing industry. Slowly, services industry is also moving to China. That was the primary reason United Kingdom voted for Brexit, because a lot of ordinary citizens of UK were not getting the job opportunities at a local level, and they were all being captured by citizens of the Eastern European nations who were now becoming a part of the European Economic Community. The underlying factor is the citizens, their stability in their lives, the job security, the economic prosperity of the citizens of a particular country. Whenever that is threatened first, or it is perceived to be threatened, that is how then, if I may say so, a feeling of resentment or jealousy manifests itself today. The today, the threat to world peace or world or calm in international order is because of prosperity is but economic prosperity. Because as Thomas Friedman said in the of goods or services can take place the place, and that 19, but is it going back to those countries where the labor charges are very high, where the minimum standards are very high? No, it is still coming to Southeast Asia, we Africa, but it is in Japan. At the same time, China is also flexing its muscles. What it did in Hong Kong, very quietly, it slipped in an amendment and basically subjected everything in Hong Kong to its own systems, which now is again being used as a potential flashpoint by the West to say that Hong Kong is no longer autonomous. So the issue to me is not so much a quest for territorial of one's place for the citizens. As long as we can ensure economic prosperity, to my mind, there will automatically harm in the internet with what they are getting of some other nation. I'm sorry for any interrupted visuals or audio. Thank you so much.
We are thankful, sir, for your wonderful lecture. I think the participants would have been enlightened. There was some disruption, but never mind. Now, I would like to call Professor Mohammad Ahmad, Director, Placement Committee, and the organizing secretary of this event for vote of thanks. Sir, please.
Dear friends, my colleagues, chief guest, our team has started a series of webinar, and this was I think third webinar, and in this third webinar we have discussed on the quest for international peace in the 21st century, and it is continuously for 3 days it was continued, and today it is the valedictory. This chief guest of our this program was Professor Dr. Adhish Agrawala, about whom I was always thinking that he should be invited by us to as a chief guest, and ultimately we have got this opportunity through the acceptance of as chief guest of Mr. Adhish, Dr. Adhish Agrawala. The speakers from top to bottom, Professor Rakesh Chandra, Department of Philosophy, Lucknow University, deserves thanks. Prashant Shukla, Professor Manuka Khanna, mm, Professor Dr. Bhanu Pratap, Mr. Miss Swati Singh, NLU Jodhpur, Mr. Vijay Krishna Tiwari, NLU Kolkata. These were the speakers. So I am very much thankful to Dr. Adhish Agrawala. He is not only an eminent lawyer, but he is also a social worker, as well as he is also the president of the International mm, Jurist Council. He is working so much, and he works so much that if any person who is connected with law or legal field, if he does not know about him, this means that he does not know about anything in law, because the law or legal field begins with the name of Dr. Adhish Agrawala, the eminent royal. He was the chief guest of our inaugural program, and these were the speakers from various discipline and various institute. I am also thankful to these professors and these of our university, University of Lucknow, as well as from abroad, means from other states. Now, today, since we are at the end of the this session, and it is a valedictory, I would like to submit my special thanks to Mr. Rahul Agarwal, Advocate, Allahabad High Court. He, so far as my knowledge is concerned about him, he is at this early stage of life. He has earned a popularity and other things more, which he deserves for. and he is not only law graduate but also he did master's degree from abroad. His expression which was he was delivering, I was trying listening a few in spite of few interruptions. He has well systematic way he has explained the present day scenario and the past. He was not only a he does not he did not know only expressed his view in the traditional way, but he has expressed his view traditional medium as well as in the present day scenario. He has brought some new things before us. So I am also thankful to Mr. Rahul Agrawal, Advocate Allahabad High Court. He deserves for special thanks. So all the students, participants, as Dean Faculty of Law, Lucknow University, Professor Rakesh Sri, because I can't avoid him because Professor Rakesh Sri was the person who has given me an opportunity to work for seminars, conduct seminars and various other activities. So I am also thankful to Professor Rakesh Sri, former Dean Faculty of Law, who has launched me for the working of such seminars and other activities. So he has also very nicely explained Dr. Bhanu Pratap. We can't say about anything because he is an extraordinary person in the field of law, as we know, because he belongs to our faculty. Although every person has explained in accordance with their own view and knowledge very nicely, and it was very acceptable, and also it will play a vital role for the for our webinar, and we will continue such types of webinar, and we will invite all these people because these people has very nicely explained us, and we could understand it easily. So on all these two words, I am again submitting my thanks to Mr. Rahul Agrawal for being with us. Thank you, and also I thank to the Mr. Saksham Agrawal and his team, Shishir, mm, Sachin, Shikhar, and others to be active and very actively. They have organized this program. So dear students and the student committee, I'm also thankful to all of you for being continuously to conduct this program in proper way. So thank you so much.
Saksham, you are live now.
Thank you. Thank you, sir. I'm thankful to all these speakers who were with us for the last 3 days. I'm thankful to our chief guests, Adish Agarwal sir and Shri Rahul Agarwal ji. I'm thankful to Professor Mohammad Ahmad, Professor Ake Singh for their valuable support, and our Dean sir who is not there today with us due to some problems. I'm thankful to the organizing committee for organizing such a huge webinar wherein more than 500 participants were there from across India. I hope that we all are safe during this pandemic, and I must assure you that we are going to have with us very soon a huge webinars. Thank you.
I thank all the speakers for their insightful content and uh, taking us through the quest for world peace in 21st century. Where on the day one we saw Ms. Swati Singh Parmar explaining the international peace through the uses of law, and then Professor Manuka Khanna, who explained role of superpowers in resolving conflict. On second day, we revisited the perpetual peace concept by Professor Rakesh Chandra, and then Professor Prashant Shukla explained the critical exploration of Plato's position. Then today, Dr. Bhanu Pratap explained the legal monism, and Mr. Vijay Kishore Tiwari explained the quest for world peace from the lens of the third world. Thank you, participants, for attending this webinar.